Welcome to Windows on the World. Join us live every Sunday, 8 p.m. UK time, windowsontheworld.net, and do check out the archive and programme stream on the website. This show is one from the archive, and do check out the links below. Well, over the past 20 years, many so-called remedies have been pushed which actually make matters worse, as they are seen by, for instance, a court as dishonourable. And this means that anyone using arguments such as the free man on the land type argument is automatically deemed to be an incompetent and therefore a ward of the court. Competence is essential, and only with competence can one have any standing in law. This show also includes information on competence. It's not legal advice, but legally correct, and everything stated has been tried and tested. This show covers birth certificates, estates and liabilities, the use of Admiralty Law since the 1200s, along with the creation of legal fictions and how remedies may be hidden but are actually built into law. This show covers a lot, from how courts operate to what is behind council tax, the connection between the modern passport, the poor laws and the certificate of settlement of the 1600s. The registration of you as an estate on a roll or register by a parish ties in today with what is happening alongside the devolution of councils, and conversely, the creation of more parish councils, which has happened over the past 15 years, which has led now into huge unitary devolved bodies. In other words, remote, unaccountable authority. So this show is quite a few years old. I've had emails asking me about this information, so I'm going to put this one up on the YouTube channel. It's useful for anyone who wants to manage their business to their own advantage rather than for the sake of financial parasites whose system is actually based on fraud, and remedies are also covered. But do check out the links below. So at present, there is no rule of law. The communitarian concept of the common good means the innocent are routinely punished for the sake of imposing the power of remote authority and all of its agents through the executive, legislative and judicial bodies enforce a consensus reality. Well, for example, the labelling of already state-infiltrated protests as being far right. The protection of the community, the technocratic defined community that is, which excludes and punishes all that is outside the imposed corridor of communitarian opinion, is what we're actually talking about here. We're talking about lack of any real system of law. And we did an article on this called How Communitarian UK Courts Operate. Check that out, the link's below. And the Communitarian Agenda is an article which you may want to look into if you want to know how global to local governance works. And the related articles are on windowsontheworld.net and also below. So they're linked below. They are you a pauper? Is a birth certificate a death certificate? Those are two different articles. And there's an article called What is Common Law? And that has many links underneath, but all the links you need are underneath this video, and I'll put them into the comments also. So this is a show from about 6 or 7 years ago, and it's in our archive on the Spreaker shows archive, which is in the live shows page at windowsontheworld.net. So hope you find this useful, and we are not advocating any of the current fake remedies which are out there. So please don't put any reference to that in there. This is all tried and trusted information.
The thing is about this, Tony, is that often authorities do not want to acknowledge that you've had an effect, because obviously that's not good for the status quo. That's going to take us into what we're going to talk about tonight. As we know, everything is linked. But I think that's a very important point, especially with this stuff with the police. We effected a change within the procedures of Kent Police and the way that they were abusing the Crime Stoppers website. And that was never acknowledged by Kent Police. In fact, I kept stating it to them that we had effectively made them take down their allegedly most wanted criminals, and that those people were not wanted in the first place, and we've proved it. And of course they go a bit silent and try and divert you onto another subject, but that's another issue, and one that we have covered, and one that I am going to continue to cover, because this this issue with the police and what's happening to the police, and the fact that they're openly announcing that they're not going to attend for what they call minor crimes, which could be your house getting burgled and all your possessions being taken. They don't consider that to be important anymore. But we know what they do deem to be important, because it's being put into them by lobbyists, is things like hate speak, which cannot really clearly be defined, and is, as we know, a big impediment to us in our search for remedy and free speech, because hate speech cannot be defined. So therefore, it's just really Big Brother telling you to shut up. And we've had some good results with dealing with that as well, because if we go into law and look at what we are actually here to represent in the system, then it can get to some very useful outcomes. And we're going to be talking about that tonight, and what we can do to empower ourselves within the system, because I've been looking at this for very many years, and a lot of people have made a lot of mistakes, and those mistakes were all, they were in good faith. People really thought that this stuff could work. Lots of different remedies were tried, but there are remedies within the system. I found them myself, and we're going to talk about what the system thinks of us and what we can do to redress that within the system. And we're going to have a guest on in part 2 of the show, Paul Webster, who I've spoken to before, and we've talked about this issue of liabilities and debts and all the rest of it, and the financial system. But we're going to go into, first of all, what we are to the system. Now, this may seem a bit abstract to some people, but several years ago, I wrote to the Passport Office, the Home Office, and asked them what the P on the passport actually stood for. And they gave me the most absurd answer you could possibly imagine. They said that it stood for electronically readable passport. Well, how can a P stand for electronically readable passport? And the P was on the passport before they were electronically readable, because I had one which was before passports were electronically readable, and it still had P on it. So that means that the people in the Home Office don't really know what the P stands for. But when we go back into the system of law and ancient law and liability, the P actually stands for pauper. Now, people are going to say, well, how can you prove that? Well, I can only prove that by looking at ancient systems of law and the fact that we were made to be paupers. And a pauper is described as an impoverished person who is supported at public expense. Let that sink in for a minute. An impoverished person who is supported at public expense. Now, we're all supported at public expense. People say, well, why is that? Because in the system that we're in, we have a system of taxation and liabilities from local authorities to us. It came back into the poor laws, and also the certificate of settlement, which we'll get onto in a minute. But that, I think we should repeat again. An impoverished person who is supported at public expense. Are you eligible to draw benefits? Most people will say, yes, I am. Why are you eligible to draw benefits? Because you are a ward of the parish which you inhabit. You are owned by the parish, because the certificate of settlement, which came out of the poor laws, meant that you could not move from one parish to another. In other words, to one jurisdiction to another. Not that each parish had a separate law. It was just that you're moving from one judicial area to another, because they all had magistrates. So in other words, you had to prove that you could support yourself to go to the next parish. And we'll get onto that in a bit, but we'll carry on with this. It can be an indigent litigant who is permitted to sue or defend without paying costs. Are we eligible for legal aid? Well, we're not really anymore, but legally we are. An impoverished criminal defendant who has a right to receive legal services without charge. That's a pauper. That is the legal definition of a pauper. So when you go into a court, you're deemed to not hold property. A pauper cannot hold property. And that's really important, because when you are represented in a court of law, you are property. You are the property of the court, and people will have real difficulty understanding that. But we've covered it in great detail. And it's all about liabilities. So, in other words, a pauper is one so poor that he must be supported at the public expense. Now, we're all wards of the parish, so we all are supported at public expense because we are all liable for our own debts to the parish, what they deem us to owe, which was where council tax came from. It came out of the poor laws, but they have liabilities to us. Now, what's interesting is those liabilities have been forgotten about by the council. They just assume that we are there to serve them. Well, it wasn't like that. They were there to serve us. Now, that laws might be draconian and might make assumptions on our behalf because we consent to them, and we consent to them through the birth certificate, which was originally the certificate of settlement. Now, a settlement certificate is an official document issued to a validly recorded pauper. So in other words, you didn't really have a choice. If your parents registered you, then you are a pauper. But it has good things about it. You do enjoy the benefits of the state, which is dole, pension and imprisonment and fines. These are all benefits of the state. These are the benefits that we get as being paupers. And that is something that most people do not understand because they think they support themselves. But in this system, you can't support yourself because you are always liable to that third party, whether it's your local authority or the Crown. And remember, in recent years, local authorities have been getting more and more power. So in other words, this is regional governance. We used to have national governance. Now we have regional governance done under international governance. And we talk about this all the time. And of course, the governance that we're really talking about, above it all, is unstructured. But the government which operates within the legal system is structured. For instance, let's have a look at the United Nations. That operates outside international law. They cannot be prosecuted. So they are a lawless organisation who operate above the law. Therefore, the unstructured government we're talking about is organisations such as the United Nations. They are an unstructured government. How a structured government is now really liable to unstructured government. And that's what's happened. That's exactly what we talked about at the beginning of the show. That's why those council officials might now start backing off, as they did in Haringey, to joining up with these huge corporations. Because another thing about it we have to remember is vicarious liability. Now, vicarious liability, I don't get too complicated here, is the people who are associated with an organisation, legally associated with, a bit like a marriage or a partnership. Well, they are vicariously liable. So what we have to remember is these councillors and people who are taking on all of this responsibility are vicariously liable. Now, they really don't want us to know that. And I think a lot of what's coming out, especially with the Haringey development vehicle, which was basically putting all of the council-owned property into a huge conglomerate owned by Lend-Lease, a huge Australian corporation, they were worried about vicarious liability because it means if the public find out any wrongdoing, they're liable. They're as liable as the corporation that their council is representing. And that's something I've just thought of, which is very, very important. But all of this liability and debt, stuff people talk about, it all revolves around this subject. And we have to look into these poor laws and what they really are. So yes, a settlement certificate is also now known as a birth certificate since 1837. It's an official document issued to validly recorded paupers, granting them certain basic rights and entitlement to benefits in exchange for recognition of their status as being owned as property. Unlawful slaves, also known as indentured servants and bondsmen. A settlement, therefore, is equivalent to a voluntary slave plantation. And that's another very important issue. We have a plantation which was without the jurisdiction of Britain, along with other jurisdictions, which we don't need to go into now. such as the UN. The UN is a jurisdiction without the country that it resides in at that present time. But again, it's also not liable under international or even universal law, as they call it. So that's an interesting one. But basically, yeah, people can't get their heads around that we're property. But this is a very interesting point, and one we're going to go into. And the thing is about this, that most people will know about the county court. Now, we've heard a lot of people talk about this over the years, like the courts of Admiralty. These are going to come up in part 2 of the show when we talk to our guest. But the courts of Admiralty, as they're called, put us into this jurisdiction where we are in the Sea of Commerce. And because we have been pronounced dead for 7 years under the Cestui V Act of 1666, then we are assumed to be property after the age of 7 years old. And that property can be transferred because we didn't object. The objection has to be raised within 7 years. And if you look at basically deeds and assignment and bills, a lot of stuff is actually wiped off after 7 years. That's under statute. You can look that up. And that's an interesting one as well, because the bill itself, the person who issued the bill, is presumed to be dead and not functioning after 7 years, the 7-year rule. Very interesting one, that. But the development of Admiralty jurisdiction, which is what we're in, this Sea of Commerce, which we're going to be talking about, everything has to be dotted and crossed correctly. Whereas in common law, say the difference between a county court and a criminal court or a crown court is that the crown court summons the corpus, which is the body of the person, but the Admiralty Court or the Court of Commerce, which is the county court, summons the person, not the corpus. The corpus is the real body, and the real body does not. This is an interesting thing. Under Admiralty law, the person has to be identified correctly, and the name has to be absolutely right, or it cannot go through. If there's any problem with an address of service or the name, Admiralty law becomes very problematic, which is why they have to invent fraud. And there's a lot of fraud going on. But under this jurisdiction of commerce, which we're in all the time, actually, and as paupers, we should really know why we're in this Sea of Commerce. And it's been stated from years and years ago, from the 1200s, actually, by lawyers, that this Admiralty jurisdiction caused problems within the courts, and lawyers even then didn't like it. This is from the development of Admiralty jurisdiction and practice since 1800, which is a very interesting book. I'm going to quote: "For reasons which ranged from petty jealousy to righteous indignation at real encroachment upon their jurisdiction, the courts of common law very soon became resentful of the power exercised by the Civil Law Court of Admiralty. As early as 1296, the authority of the Admiral to adjudicate disputes involving seizure at sea was denied by the Common Pleas, and in the late decades of the 14th century, and the steady acquisition of Admiralty jurisdiction became intolerable to the common lawyers. Their remedy was to obtain statutory restriction of the Admiralty jurisdiction to a thing done only upon the sea." And that's really important, that they knew that this Admiralty law it's a jurisdiction of the sea, which has totally different courts to on land. In other words, they're taking away a lot of common law rights, because sea is commercial, and commercial codes are very different from common law. And I don't know whether this is getting too complicated for people. Are you understanding this so far, Tony?
I am. You're doing a good job. Well done.
All right, mate. Yeah, because this is a problem I have, that because I'm kind of versed in this, it's over the years I've been in touch with people who really know this stuff. And the problem that they generally make is that the public know it too, or the people who are listening to them know it. And it's very hard for people to get their heads around. I've got friends who have written incredibly detailed and accomplished work, and they can't understand this stuff. Some people have a problem with it. I mean, I have a problem with certain mathematical principles, unless they're explained to me. I'm better at literacy, but some people have a problem with this, actually understanding it. But basically, it's about us being property within the system. And the acknowledgement of that is very important, because we all carry that passport. It's got a P on it, we're paupers. Now, as I said, even the Home Office do not know what that P stands for, or the people involved in it don't. So what people turn around and say is, well, it's a conspiracy theory then. No, it's not, because we're looking at ancient documents here. I've just told you what a pauper was, a legal pauper, and we're all legal paupers. So that's very important. That's why our estate can be charged. That's why we can be made bankrupt, because we are liable, because the Crown has indemnified us basically through that birth certificate. And the birth certificate, which came from the certificate of settlement, basically we're talking around the poor laws, which really started about late 1300s, and there was lots of different amendment going on through the poor laws. We don't need to go in that, but we had the Poor Relief Act, 1601, I think, the Poor Relief Act, and then we've got the acts that followed that into the 1500s. Basically, the first poor laws were promulgated around 1535, but there are obviously, yes, from the late 1300s, we can say that this kind of, well, enrolment to the Crown really started to happen. It's coinciding with the first official mandate requiring uniformed record keeping by all Church of England parishes. Now, your local council is your parish, and what they've done recently, they've formed all these parish councils, loads of them. And people think, oh, that's a good idea. It's tea and cakes with the vicar. No, it's not. It's about more and more power being taken by councils under the guise of being called a parish. That's important. So there was this first official mandate requiring uniform record keeping by all Church of England parishes was in 1535. That's of all births, deaths and marriages. The poor were considered the responsibility of the church, including ensuring they had ample work and did not starve to death, as they were considered by default the property of the church. Under Elizabeth I, a set of measures which were introduced, which had the effect of accelerating the disenfranchisement of land peasants into landless paupers. This is important. Under the Erection of Cottages Act 1588, peasants required local parish permission to erect dwellings, whereas before the erection of a dwelling by a land peasant on their lord's land was considered a right. As a result, the ranks of the landless poor or paupers swelled. So in other words, the feudal system was better. The people who actually claimed to own the land, remember, this is all about a claim. And if we can go to the biggest claim ever, it was, of course, Unam Sanctum, the papal bull enacted in the 1300s by Pope Boniface in the early 1300s. We don't need to go into that. We've been to before, but basically it put the whole world into trust under the papacy. And we basically became, the bishops were the trustees, the clergy were the trustees, and the Roman Empire were actually the beneficiaries. So it's an interesting one when we look at it, because the act of trust is the most important thing. And when we become benefice, if we have benefice, which is given us by the church, then we become the beneficiaries. And we are the beneficiaries of taxation, we're the beneficiaries of welfare, we're the beneficiaries of pension, but we're also the beneficiaries of all the fines and the imprisonment. So it's a system which has become tilted, and it's become tilted because of the amount of financial fraud that's been allowed to happen, and our government is letting that happen. So if we look at the history of this, it's become very skewed. Of course, the poor laws meant the poorhouse, the workhouse. Now, the workhouses weren't actually abolished until the 1800s. This might sound incredible to people now, but we've got modern day workhouses. They're called prisons. And of course, private prisons are getting prisoners to engage in labour. So it's the same thing. Forced labour is the workhouse. And so we're going back to this kind of system. It's not really changed. The stuff we talk about every week is still the same. In other words, we are paupers. We have liabilities, duties, and we also have rights. So this is an interesting one as far as this development of Admiralty Law goes, which puts us into commerce. And we can go on and on with this stuff. Yeah, the Settlement Act of 1662, the Poor Relief Act of 1662, including for the first time the issuance of settlement certificates equivalent to a birth certificate, passport and social security rolled into one. So basically this universal credit is trying to do the same thing. We are being put into a much bigger system, but it's implemented with far more control. A child's birthplace was its place of settlement, unless its mother had a settlement certificate from some other parish stating that the unborn child was included on the certificate. However, from the age of 7 upwards, the child could have been apprenticed and gained a settlement for itself through so-called indentured service or voluntary slavery. Also, the child could have obtained a settlement for itself by service by the time it was 16. And of course, this Cestui Que Act made us all paupers after the age of 7 years. So it's kind of a trick, really, but the state assumed you to be competent before the age of 7. Now, that's slightly unfair in my opinion, but legal. It's all legal within the system. So yeah, the Poor Relief Act 1662, no one was allowed to move from town to town without the appropriate settlement certificate. If a person entered a parish in which he or she did not have official settlement and seemed likely to become chargeable to the new parish, then an examination would be made by the justices or parish overseers. From this examination, an oath, the justices would determine if that person had means to sustain himself. The results of the examinations were documented in an examination paper. Now, we've got to remember also that heretics were examined by the clergy and the magistrates and the military jurisdiction, which came under the church, as to whether they were heretics and whether they were going to repent or whether they were going to be burnt at the stake. So we can see a similar thing here. This is all about liability and at the assumption of liability. And of course, being burnt at the stake as a heretic was because we are allowed ourselves to be paupers. A heretic actually means one who is able to choose. So in other words, when the church talks about heresy, they're talking about people who wanted to cut out the middleman, them. They wanted to go straight to the source, and you're not allowed to do that, which is why in the legal system you need a lawyer. A lawyer or a barrister, basically a prostitute for the crown, who works as an agent to represent you, because you are deemed not to be competent. And that's very, very important. So all of this stuff carried on, and the legal theft of land under parliamentary enclosure laws of the late 18th century, early 19th century, the numbers of paupers dramatically increased. This led to the most awful and cruel laws being introduced to deliver to an elite few the slave labour force needed for the Industrial Revolution through the Poor Law Amendment Act of 1834, which effectively stated that the poor could not receive any benefit unless they were constantly employed in a workhouse prison. Now, we see something very similar with this universal credit. In other words, you have to be able to prove that you're earning a certain amount to be self-employed now, whereas previously you didn't. So it's going back to this kind of system, in my opinion, and in a way that most people don't quite understand, because it's presented much more as a benefit. Everything is presented as a benefit. So unless we look at this stuff and analyse it, then it's all for our benefit. So
apparently, yeah. We have got quite a few comments and questions from the chat, but I'll leave you until you're ready for those.
Despite international treaties against slavery, the very worst slavery, being wage slavery or lawful slavery, was born, whereby men, women and children lived in terrible conditions and literally are worked to death. So there you go. Now, the birth certificate, in 1836, let's jump forward to that, the Births, Deaths and Registration Act was introduced, which for the first time created the General Register Office and the requirement for uniform records of births, deaths and marriages across the empire by municipal councils and unions of parishes. On July the 1st, 1837, the birth certificate was formed as the successor of the settlement certificate for all paupers disenfranchised of their land birthright to be considered lawful or voluntary slaves, with benefits provided by the local parish or region, underwritten by the Society of, it says here, of Lloyds. Now, I'm mixing up some of my stuff with other researchers here. So it's an interesting overview. So basically, we've got all that goes into Local Governments Act, and since 1990, under the United Nations and the World Health Organization, by the Convention on the Rights of the Child, the system of issuing birth certificates as proof of a man or woman being a permanent member of the underclass has become an international system. That's quite important, because a friend of mine had 3 different birth certificates, because when she came to this country, her parents couldn't write. So her name was nothing like her real name. So she had a birth certificate for that. When she got married, she married somebody who didn't actually have a real name, but it was a name imposed on him by a court in Cyprus, and his family. And he became known as Mr. Yaramaz, which meant Mr. No Good. So when she married him, she became Mrs. No Good. And then she found a real family name, and she got another birth certificate, which was in her real name, which was Hussein. So she had 3 different birth certificates. That's why they want to centralise everything, Tony. It's only administration, it's not personal.
Yeah.
But that's an interesting point. And we've looked at this stuff on Windows on the World previously, and I think it was our gateway into what's going on, because it's a real shock to most people when they find out that they are property and they're paupers. And because they're paupers, they are deemed to be property. And most people are so spoilt, in a way, by the system that they can never acknowledge this. They go, I'm not property, I've got a house. But do you own your property? Yes, I own my property. I have a title deed for the property, but the title deed is not the property. Yes, it is. I bought it through a mortgage, etc. You don't own anything. So
you can't own property or land without what's known as a allodial title.
That's right. There was some allods still left, I believe, up in Scotland, but all that's gone now, and it's all claimed by the Crown anyway. So, interestingly, it's now all being usurped under the United Nations, under this Agenda 21, Agenda 2030, which, according to the illumined Clyde Lokes of Waltham Forest, is a conspiracy theory. Yes, all 40 chapters of Agenda 21, the UN programme of world governance, is a conspiracy theory to Mr. Lokes, who actually gave us the best quotes he could have possibly done. He stated that the words of Gordon Peters and Peter O'Kane and these very learned people who came to speak in Leighton were of no value whatsoever. Thanks, Mr. Lokes. But we do like to bring him up every week. I don't think he's going to resign yet, but we need to put some pressure on with that one, because also we've got the Chief Constable of Kent Police hasn't resigned either. So they're not taking any notice of us. Is it because we're paupers? Well, wait a minute. They're paupers too under the Crown. So there must be some remedy somewhere. But yes, the birth certificate's a big one, because years ago we went into court and we put the birth certificate in the dock in the Admiralty Court, And at first, people were so puzzled by this, the magistrates, that they didn't know what to do. So some cases just slipped under the table. But there's a certain friend of mine who went into Waltham Forest Magistrates Court and never heard anything after playing our video, Councils, Courts and Comment, and basically repeating what it said. It's good fun, but it doesn't ultimately get you anywhere, because the council, as we stated earlier, consider you to be a ward of the court, because they're the parish and you're the pauper. It's quite simple, really, because it all goes back to the church, and we are property of the church, as those early acts stated. Paupers are property of the church or the parish. So yeah, the registration of you at birth is the title. That's your legal name. Mm-hmm. So your legal name in black letters on those bills is your legal name. It's your title. The registration.
Yeah, it's a legal fiction.
Yes, we've just talked about that. The creation of legal fictions was of great concern to lawyers from the 12th century, because A legal fiction is just a transference of title or property. That's all it is. But we need to be a title when we go into a court of that kind of jurisdiction, because it's not a common law court. So, I mean, all this stuff has been covered by this so-called free man on the land movement, which kind of, I think that got very much taken over, because a lot of the stuff that was being propounded by certain factions of that were totally ineffectual within the system that we actually operate. Yeah. And I found that to my detriment, but yeah. that happened with, I mean, I got into huge correspondence. This is when councils used to speak to me about 2009 with quite a patient fellow, actually, who's the financial guy from the local authority, and he engaged with me to a certain extent, but he always quoted the 1992 Local Government Finance Act, which is what they always do, to say that you're liable for council tax. Well, it's nothing to do with that. It's to do with the poor laws, what we've just been talking about. But obviously, this is going far too way back for them. But yeah, the registration of you as the person turns you into a thing on a register. So you're an estate, basically. You become an estate on a register. A person is a legal fiction title, whatever you want to call it. It's an estate on a register. So you are an estate. And you can look at the Bills of Exchange Act, and it's quite clearly laid out in there that a person basically is the thing that is transferred, the property, the title, property to be transferred. A legal person is therefore an estate created by being on a roll. The thing can then be conveyed lawfully and in commercial agreements between parties. The legal title means the child is the property of the state and not the parent. This is why in the birth certificate it states the name of the informant and not parent. First witness, if illegitimate. If you're illegitimate, there's a first witness, somebody who signed on your behalf. And again, you can look in the Bills of Exchange Act to see where that goes into commerce. It's a very similar thing. So it's all about commercial transactions, really, and how the system works. Because the registration is by consent, this means that property, the child, was given to the state willingly. Yeah, we know this. Your parents consented to register you because they were told that it was illegal that they didn't register you, and there was different penalties. It's interesting, actually, because the penalties actually for registration, they used to go down. They used to get less and less serious as time went on, until after 7 years it disappeared. So yeah, the lost at sea rule meant that after 7 years the person or the property was unclaimed and was missing, presumed dead. In order to take full advantage of the person as a traded commodity in the 17 to 1800s, everyone registered at birth was considered lost at sea, so as to be traded before the age of 7. Westminster, the palace home of statutes, was burned in 1834, and over 95% of statutes came into force between 1835 and 1899. Birth certificate became a death certificate as the registered person was presumed dead, as they provided no rebuttal of this assumption, because they can't, because a legal fiction is not living. So you always have to be traded as a commodity, as something that is dead or inanimate. The death certificate can be charged against an estate. In commercial law, the law of the civil court and admiralty, all fines and fees are paid from the estate of the deceased or living person without recourse. This is done by means of an order or writ. This is because an estate cannot be charged unless it is in probate. Again, going back to presumed dead after 7 years. In civil and now quasi-criminal matters, all persons are dealt with as though in bankruptcy, using foreclosure. The estate is administered in bankruptcy. The person is assumed, therefore, to be delinquent and an imbecile, and therefore has no rights. Takes us back to a pauper. So that's really the story so far. And when we get into commerce, we have to take all of this into account. The great news is, though, that because of the level of fraud, we can have some success. I've had some success with this in county court, and county court can be useful. The county court is now being taken away from us because we have to go online to fill in these forms. And it's now up to Northampton whether we've got a claim or not, whereas previously a claim had to be rebutted. We made a claim and someone had to rebut that claim. Now that goes back to the Bills of Exchange again, about an invoice or a bill. In other words, if I sent you an invoice, Tony, and I stated that you owed me £100 for your time tonight, then you would have to state that it was an invalid invoice. Because if I sent you 3 invoices and they were declined, then, in other words, you've accepted. What you have to do is you have to protest, or you get someone to super protest the invoice. A super protest is someone who comes in on your behalf. It's interesting stuff, this, and once you get your head around it, you realise that fighting some things is pointless and fighting other things has merit. And that's the most important aspect of this. People get into pointless litigation, and lawyers encourage people to get into pointless litigation because they make money out of it. It's much more profitable for a lawyer to be in constant litigation than to find a remedy, and that's extremely important, Tony.
Yep, it is indeed. Very thorough analysis there of what we are, how we've got here. But there's one bit that I think that you didn't touch on, and that was when you was talking about the birth certificate. There's actually 2 birth certificates, isn't there? The long and the short, and that comes into play in this as well.
Well, it does, but it depends how deep we want to go into it. What I'm giving people here are the tools that they need to understand this, because it's about the incorporation of that of you as an estate that's important. And yes, we can go into the details, but I'm talking about commerce here, and the liabilities of us as paupers. And get everyone just to look at your passport. Unless you've got diplomatic immunity, you'll have a P on your passport, and that means pauper, because it goes back that far. It has to go back to the certificate of settlement. The certificate of settlement has never changed. It can't do, because the whole system of law was set up on that assumption, and assumptions in law can be updated. And all this they're doing is updating these assumptions from hundreds of years ago, going back before the 1600s. It started in about the 1300s. So that's a very important issue here. And the issue of what's going on in county courts, we've talked about a lot. The theft of property and the lack of remedy means that the system is now in a state of decline. And the government, our government, are letting that happen. Why are our government letting that happen? Because it's not coming from them. It's coming from the unstructured government, and it's coming from the world government. And people say that's a conspiracy theory, but we've now proved it's not. And if you think it's a conspiracy theory, then write to Clyde Lokes at walthamforest.gov and ask him about conspiracy theories. And ask him if world government is a conspiracy theory. See what he comes back with, because we need more quotes from him. I don't want to keep picking on him, but it is fun.
It's conspiracy, but it's conspiracy fact. So there you go.
Well, exactly. Of course, it's a conspiracy. It only takes 2 people to conspire. Conspiracies happen all the time. There's conspiracies happening in every pub in the country right now. Well, the ones that are still open.
Absolutely. We're conspiring right now. We're conspiring to make the world a better place one way or another.
Absolutely. Now, we've got to look at the whole system here. And some people talk about oaths. And, of course, Jesus said you shouldn't swear oaths. Well, it depends who we're swearing that oath to. We should swear oaths to ourselves to be true and to be honest, because those oaths to ourselves, which I believe we are swearing, it doesn't matter whether you swear them in a court, you have to swear an oath to yourself. I don't think you should be swearing it to anybody else, because it's only you who can actually honour that oath. So basically, this thing about oaths is very important, and a lot of this stuff that's gone wrong is because people aren't swearing oaths to themselves or to a higher power, and that is a big problem, the taking away of liability. In other words, how do we get recourse? I've been trying to get recourse against the police for 2 years. You can only do it through their system, as we explained. We go to the Independent Office of Police Conduct, the replacement for the IPCC. See how far you get. They state on their website that they can instigate their own investigations. When I phoned them up, they proved that they couldn't. They said you had to go back to professional standards in the police. So the police have to investigate themselves. Professional standards of the police force that I was dealing with were not fit for purpose and were part of the problem. Therefore, there is no remedy. And if there's no remedy, there's no law, because law has to offer remedy. Equity has to offer remedy. So that's an important thing. If we're dealing in true equity, which is what commerce should have, then there has to be a remedy. And we're going to be talking a bit about that in the second half. We're going to talk about the Bills of Exchange Act. I mean, I hope this is not the administration word that people fear, because we're going to try and give it a bit of context. And you can have a bit of fun with this stuff when you know about it. And when you're talking about liability, vicarious liability, all the rest of it, and start to quote things, you'll find that these officials will often drop everything and run away, and you'll get an answer from somebody else, or you'll get a brush off from somebody else, or you'll be dealing with someone legally qualified. And that's very important, because when you're dealing with the high-ups, things change. If you go to a master at the Royal Courts of Justice, they have to offer remedy. They judge you to be a pauper when you walk in. You have to prove that you're not, because if you are there as a pauper, then get yourself a lawyer. What are you doing talking to a master? You've got no rights to talk to a master in law if you are a pauper. But you have to prove competence. If you can prove that you're competent, you're acting above the definition of pauper. So if you're competent, it means you're not being put in the workhouse. But if you go to a master and you can't explain yourself, go to the workhouse, get yourself a lawyer, get representation. I can't help you. That's the way it works.
Yep.
And it's a very amusing thing going to see these masters, because it's like going back to Dickensian times. You walk into the Royal Courts of Justice and they go, "Come in. You know, how can I help you?" And if you can't explain what it is you want them to do within 30 seconds, they'll start looking around the room and saying, "Well, I should get a lawyer if I was you, or I should attend court if I was you." And the funniest thing was, when I tried to get remedy there, I told them what had happened. I told them it was a matter of trust. It was about trust property. Someone was making an assumption about property, and basically trying to grab property on a very small amount of money, which shouldn't be allowed. But if you get a bent county court judge, they will allow you to do it, and they'll employ their bailiff mates to kick your door in, and they'll enjoy it as well. And the police will have a helicopter and dogs, and they'll get Mighty to shutter up your house, and then they'll get it sold to their third parties, estate agents, who I won't mention, and I know who's doing it in this country, by the way, and they're very big estate agents. They will then actually sell your property through their own auctioneers, and everyone's happy because it's all done in private, you see. It's not public. So this is where the problems start, things being done in private, because all courts should be public. And it goes into big problems when they're private. It's like star chambers. Star chambers were places you went for just to be dealt with, basically. You didn't really have a say. And we're going back to all the heretics, the people who could choose, the star chamber. So basically, we're looking at competency. If you're a pauper, you're not deemed to be competent. And if you were a heretic, you were presumed to be by the church somebody who could choose without their input. In other words, you could be independent. You're not allowed to be independent. It's far too dangerous to the church for you to be able to make a decision. They have to make the decisions on your behalf, just as they do in law. So that's why the churches control the parishes. It's very interesting, because we're going back to ecclesiastical law here, canon law. And canon law is interesting when it's looked into. And of course, when you go up to the 15th century, they had their own generals, and you had to stand in front of them. They had their own courts. So things have changed, but not that much. But getting back to the master, that was great, because he said, "Well, I should go there if I was you. If there's a problem with the trust, you need to go to the court." And I said, "Oh, right. Well, that was really helpful." So as I'm walking out, he goes, "There is one thing, but I wouldn't recommend it." I said, "What's that?" He said, "There is some doubt as to whether judicial review runs to the county court." And what he meant by that was that I know that fraud is happening in the county court. Your remedy is to get it out of the county court into a court of equity, a high court. That's your only remedy. So there you go. I think we've gone into that in quite some depth. It may still be a bit confusing to people, but to explain this in a completely thorough way would take days. So I've tried to shortcut it a little bit here and there. But all ministers, monarchs, officers, administrators, trustees are under oath. Now, it's very important. I take oaths very seriously because I take the oath myself. And if I say something, my word is my bond. And the problem we've got is that people do not think that if they're in public office, that their word has to be their bond. For instance, the council will go in and they won't have the correct information in your council tax case, and they will just busk their way through it and basically lie. They will perjure themselves and the council in front of a magistrate. And if you point that out, that magistrate will act, especially if they're legally qualified. So, yeah, that's an interesting kind of angle, because when you deem yourself to be competent, a lot of things change. You have a different kind of approach to the system. In other words, oh my God, I'm not scared anymore. I don't have to put that under the mat. I'm going to actually confront it. And that is very important, because if you accept things that are sent to you, then you accept that they are competently written and they have a cause. And by acquiescing, you're accepting. Tacit agreement, they call it. It's agreement by acceptance. So if you ignore something, you're basically accepting it. So that's something that, when I found that out and looked into it, I realized that the fraud that was going on. And you think, well, what's the remedy to the fraud that's going on? Well, we have to act in interests outside of the fraudsters. And that can be tricky. And we're going to be talking about that a little bit in part 2. So, Tony, did you have any comments or questions? Or
yes,
anything?
the chat room has been pretty busy. It looks like a few people have got booted out. If you're having that problem, just sign up to Chatango, get yourself an account. It makes it easy. You won't get booted out of chat. Thanks for all the contributions. Mithrin says, all rights in law are derived from property. I think we'd agree with that, yeah?
That's what I was saying. That's what we've been saying from the beginning of the show. Yes, exactly. Yeah. And the assumption of us as property. That's the whole point. Yeah, we're assumed to be property. Well, that is the whole point.
To be fair, these comments are from a long way back. So.
Oh yeah.
Right.
No, absolutely. No, that's absolutely true.
Noah says you don't have rights, you only have privileges, which I don't agree with, because I believe.
Not correct. I think we have rights. You have inalienable rights. Or as they call them in America, inalienable. But they're inalienable rights. They are rights which cannot be liened. But these are common law rights.
Yes.
Now, under the system of administration, you are deemed to be property. But if you are competent, then you can bring forth your argument. Therefore, if you have an argument, you have rights. You only are property and have no rights if you have no argument. If you are unable to argue competently, then you are deemed to have no argument. It's like when I went to see that master. You are put on the spot and he's testing you out. He's saying, okay, I'm going to bully you when you come in here. I'm not going to allow you to sit down. I'm not going to allow you proper time to make your points. I'm going to see if you can tell me in 30 seconds what the remedy you seek is. And if you can't do that, out the door. You're incompetent, you're a pauper, get representation. I think that answers that, doesn't it?
It does. And there might be another answer to it as well, but it might be for another show. We'll talk about it after, but it's to do with legal person and man, and the differences there as man.
Well, that's the difference between the common law and administrative law, which I was talking about. That's why lawyers were particularly concerned, even in the 1200s, about this crossing jurisdiction. And what we now have is quasi-criminal. In other words, bringing back the debtors' prisons. Well, that goes into quasi-criminal, because that means corporations can cross over, and that's why people get put in prison for council tax. It's slightly different with council tax. As I said, it goes back to the poor laws and the workhouse. All they're doing by putting you in prison for council tax is putting you into the workhouse. That's all they're doing. It goes back to the poor laws. But there's no need for anybody to get put in prison for council tax. And I was going to cover that a bit tonight, but I don't think we've got time. But a friend of mine basically, she sent me the documentation which to put her in prison. It was called a no bail warrant to get her to the court. In other words, they were seeking final remedy. They needed to get her to the court. She wasn't under arrest, but they were about to instruct a third party to bring her to the court. Now, they can't do that because that's kidnap. And this is what Waltham Forest tried to do with me. So I phoned them up and I said, the CEO of Waltham Forest has threatened to kidnap me, because that's what it is. It's a threat of kidnap. And that is important. And it's good fun as well. Because if you phone up the council, which I did, I phoned up the council and the call centre. I said, I've had a threat of kidnap. And he goes, well, we'll call the police. I said, well, no, I need to inform you because it's your CEO who's threatened to kidnap me, and I need to get through to them to tell them that I'm not going to allow that kidnap. I'm going to state that that's an illegal act. And he's just started laughing. And when I explained it to him, he said, well, good on you for trying. He said, I'll try and put you through. And of course, I left that on the answer phone. I said, it's Friday, and he said, I'm very worried about this. I've had a threat of kidnap from you, and we need to remedy. Otherwise, I may be making a counterclaim. And it was left at that. But that's the thing. These public officials, they send out this paperwork and they don't realise the importance or the seriousness of what they're writing.
No, they rely on people's ignorance and nescience to get away with what they do, because, you know, if there's no response, then, you know, it's all right. It's kosher. It's good.
Yeah.
Right, can we move on? We've got...
oh, please.
Okay, we've got a new face in chat. We've got a few new faces. Nice to see you there. Thanks for joining us. We've got Deborah in. And Deborah says, hi guys, love your work. Thanks for that. Thanks for your support.
Yeah, thanks a lot.
She says, changed my surname by deed poll after divorce. Is this deed poll an extension of a birth cert?
Yeah, because you've done it by agreement with the state. So in other words, it's a legal name. It's a legal title. Yeah. Anything, a deed, basically, yeah, so you're transferring. You're just transferring your asset from your old name to your new name, which is your estate becomes your new name. That's all you're doing. Yeah, you're still liable.
Okay.
What's interesting actually, Deborah, is that the system sometimes doesn't keep up with it all, and that's where it can get fun. That's what I was saying about my friend having 3 different birth certificates. I thought the the opportunities for financial gain, or as they prefer to call it, fraud, are quite large there. But the City of London does it all the time, and I don't think they'd mind me saying that, because we're talking about gentlemen's crimes here. We're talking about something that is just a transference of title. Mm-hmm. And deeds and titles can be transferred, as we know, and the City of London does not commit fraud. It just transfers titles and deeds. I mean, this stuff does work. I mean, it's not a vague concept. This stuff does work, and it's about property. So if we know that when we're in these sort of courts, we're being classed as property, then the only thing that a property can do is to not be property, is to become competent within that system. Otherwise, as I said, you're deemed to be a ward of the court or the parish. And that doesn't matter whether you're in county court or whether you're talking to a master. Now, we can't really go into how bent the courts are and how they're directed, and what happened in a Crown Court case where I went to, where the judge completely led the jury, in my opinion. He undermined my testimony. And that is a problem. And that does happen in county. It happens more in counties every day because these cases are more regular. You know, they go through county all the time, and fraud happens in county court an awful lot. So I think that to become competent in this stuff and have a vague or even literal understanding of it is very important. Yeah, just to finish this half off, various devices consisting chiefly of legal fictions were employed in the common law courts to enable them to adjudicate maritime matters actually within the Admiralty jurisdiction. But when retaliation in kind was attempted by the civilians in the Admiralty court, they were thwarted by common law writs of prohibition, and that was in the 1200s. So nothing's changed, does it, Tony?
No, I don't think so. More comments here. Totally agree with swearing on an oath to self, and there's people talking about sheriffs and other things, but we won't go into them tonight. I will save those questions because I'm pretty convinced that we are going to do a follow-up to this. There's more to this, and we can bring them in then. We're out of time for today, but thanks for the questions anyway.
Welcome to Windows on the World. Join us live every Sunday, 8 p.m. UK time, windowsontheworld.net, and do check out the archive and programme stream on the website.